हेलो।
एक मिनट, यूट्यूब लाइव का रेडी करना है। ओके, good evening, friends. In our series and an endeavor to enrich the society at large, we have been bringing speakers who have immense knowledge. In that pursuit, we have
Your voice is not understandable, legible
just hold,
because
just hold.
something is happening. So should we wait for some time?
Just hold. Now, is it audible?
Yes, it's audible.
Good evening, friends. Amongst us, we have Justice Darshan Singh, a former judge of Punjab and Haryana High Court. As those who have been connected with the series of Beyond Law CLC would be aware that we have been trying to enrich ourselves as well as society at large with speakers with immense knowledge, and today's session is also in that pursuit. Circumstantial evidence, what are the basic principles which are to be kept in mind, etc., is being explained today by Justice Darshan Singh. Those who are on the north side would be well aware about his judgments, which had deeper insights of deeper perspectives of law. And we had requested Sir to share his knowledge. He had also been the chairman of RERA. Thank you, Sir, for accepting our invite. Over you.
Good evening, friends. I'm grateful to Shri Vikas Chatrak Advocate and his team for arranging this video conferencing. The conference has given me an opportunity to be with all of you, though virtually. I welcome all the viewers and I hope that today's topic, that is basic principles of circumstantial evidence, will be practically helpful in conducting the criminal cases. First of all, let us understand the meaning of the evidence. As per Section 3 of the Indian Evidence Act 1872, evidence means and includes all the statements which the court permits or required to be made before it by the witnesses in relation to the matter of fact under inquiry. Such circumstances are called the oral evidence. All documents, including electronic record, produced for inspection of the courts, such documents are called the documentary evidence. Section 2, subsection 1, clause E of the Bharatiya Sakshaya Adhiniyam 2023 provides that evidence means and include all statements, including statements given electronically, which the court permits or required to be made before it by the witnesses in relation to the matter of fact under inquiry, and such statements are called oral evidence. All documents, including electronic or digital record produced for the inspection of the court, shall be called documentary evidence. Thus, the evidence has been almost similarly defined under the old and the new act. Word evidence signifies its origin, the state of being evident, that is plain and apparent. Word evidence has been derived from Latin word evidentia, which is derived from the word advere. It implies to show distinctly, to make clear, to view, or sight, to discover clearly, to make plainly, to ascertain, and obvious to prove. Evidence should not be confused with proof. Actually speaking, term proof and evidence are distinguishable. The proof is the effect of the result of evidence, while evidence is the medium of proof. According to Stephen, but evidence, as generally implied, is ambiguous. It sometimes means word uttered and things exhibited by the witness before a court of justice. At other time, it means the fact proved to exist by those words or things and regard as the groundwork of inferences as to other facts not so proved. Again, it is sometimes used as meaning to assert that a particular fact is relevant to the matter under inquiry. According to Sir Taylor, evidence means all the legal means exclusive of may or argument which tend to prove or to disprove any fact, the truth of which is submitted to judicial investigation. The evidence is the fundamental to justice within the legal system, serving as the cornerstone for decision in legal proceedings, including criminal trial, civil suits, and other disputes. The concept of evidence is deeply connected to the principles of fairness, due process, and request for truth. Evidence has been further divided into direct evidence and circumstantial evidence. Direct evidence is the testimony of the witness to the existence or non-existence of a fact or fact in issue. In the latter sense, circumstantial evidence must be direct, that is, the facts from which the existence of the fact in issue is to be inferred must be proved by the direct evidence. Circumstantial evidence means a fact on which an inference is to be founded, evidence which prove or tend to prove the factum propendum, that is, the fact needing to be proved indirectly by means of certain inferences or deductions to be drawn from its existence and their connection with factum providentia. The evidence used to prove those facts is the circumstantial evidence. Circumstantial evidence ordinarily means a fact from which some other fact is inferred, whereas direct evidence means testimony given by a person as to what he had himself perceived by his senses. But the circumstantial evidence means the testimony of a witness to other relevant facts from which the fact in issue may be inferred. To make the things more clear, for example, A is indicted for murder of B, the apparent cause of death being a wound given with a sword. If C saw A killing with sword, his evidence of the his evidence will be the direct evidence. If, on the other hand, a short time before the murder, D saw A walking with a drawn sword toward the spot where the body was found, and after the lapse of a time long enough to allow the murder to be committed, saw him returning with the bloody sword. These circumstances are wholly independent of the evidence of C. They derive no force whatever from it, and coupled with others, circumstances like nature might generate a quite strong or persuasion of the guilt. Though the circumstantial evidence is also the result of human testimony and subject to some fallibility of assertion as direct evidence, still the danger of all testimony is considerably less in case of circumstantial evidence. As regard admissibility, direct and circumstantial evidence stands, generally speaking, on the same footing. Circumstantial evidence is of two kinds, conclusive and presumptive. Conclusive when the connection between the principle and the evident facts, that is the factum propaganda and factum provincia, is a necessary consequences of law of nature. It is presumptive when the inference of the principal fact from the evidentiary fact is only probable, whatever be the degree of persuasion with it may generate. A person's guilt of a charged crime may be proven by circumstantial evidence if that evidence, while not directly establishing guilt, give rise to an inference of beyond reasonable doubt. Sometimes the circumstantial evidence can be very convincing and it can be incredibly powerful. Circumstantial evidence is incredibly important in criminal trials, and the reason why it is important is that in criminal cases there is probable need to prove actus reus, which is an act, and the mens rea, which is intention. In criminal cases, it is difficult to obtain the direct evidence for mens rea. Therefore, the circumstances evidence is used instead to prove the culprit's mens rea to commit the crime. The direct and circumstantial evidence stands on the same footing as regard the admissibility. It has been said that evidence of circumstantial nature can never be justifiably resorted to except where evidence of a direct nature, which is considered to be superior, is unavailable. But in present day, it is not true. All admissible evidence is generally equally accepted. Thus, circumstantial evidence is no longer excluded by direct evidence, even in criminal cases. The corpus delicti may generally be established by either species. Section 2, subsection 1J of the Bharatiya Sakshaya Adhiniam defines the term proof. In this section, there is no distinction drawn between circumstantial evidence and the other evidence. It is generally said that facts cannot lie, but a man can. And we all know that the truthfulness of the facts depends upon the truth of the witness in case of direct evidence. If there can be a chance of erroneous conviction on the basis of circumstantial evidence, so can be in the cases based on the direct testimonies. The circumstantial evidence is merely direct evidence indirectly applied. When the direct evidence to prove a fact is found to be unreliable, the circumstantial evidence having bearing upon the facts may be looked into. Generally, we have seen that when a crime is committed in the four walls of the house or within the family, like honor killing, the murder of the wife in the house, the family members do not come forward, and most of them turn hostile when they are produced in the witness box. In those circumstances, the circumstantial evidence is very helpful. The circumstance evidence sometimes can be very convincing and incredibly powerful. The direct evidence depends merely on the facts as to whether the witnesses are truthful and believable. If you believe the witnesses, the conclusion can be drawn, whereas the circumstantial evidence requires a different form of reasoning. It is a popular misconception that circumstantial evidence carries less evidential value or importance in comparison to direct evidence. It can be partly true to some extent, depending upon the facts and circumstances of a particular case. As already mentioned, the intrinsic evidentiary value of direct evidence depends upon the character and truthfulness of the witnesses, whereas the circumstantial evidence often has an advantage because it is difficult to suppress or fabricate the circumstances. Most of heinous crimes are generally committed within four walls of a house, where independent and direct evidence is generally not available. Nowadays, the crime against aged persons living alone, kidnapping of children for ransom, honor killing, doggy deaths, contact killing, rape with murder are on rise. In these type of cases, direct evidence is seldom available. The investigating agencies and the court has to rely upon the circumstantial evidence, which makes the task of the investigative officers, prosecutors, and the judicial officers difficult. The question is generally raised as to whether the direct or circumstantial evidence is superior. As already mentioned, the direct and circumstantial evidence are on the same footing to prove the case. In the cases based on direct evidence, there is always apprehension about the veracity of the witnesses. Similarly, in the cases of circumstantial evidence, as we know from our experience, that there is fear of padding and creating the incriminating circumstances. Padding is the just to create the evidence, like extrajudicial confession, planting of the weapon of offense, that may happen in cases based on circumstantial evidence, for which you have to be very vigilant and you have to cross-examine the witnesses in such a manner so to get to the truth from their testimonies. Again, the courts has to test the veracity of the witnesses appearing before it to prove the incriminating circumstances of. However, one aspect must be noted that human mind is so constituted that when a person gives evidence of having seen a particular evidence incident, it may not be accepted because of possibility of mistake. Whereas if there is a complete chain of circumstances, all logically pointing towards the existence of the fact in issue, the human mind would prefer to follow the chain of circumstances as it is a virtually it is virtually impossible for such a chain to be forced falsely and deliberately. Therefore, it can be safely said that witnesses may be mistaken, but circumstances are not. But at the same time, it cannot be assumed as a universal truth. Sometimes the facts and circumstances may be pointing to one way, and the truth is the other way. Thus, it all depends on the facts of a particular case and reliability of the evidence, either direct or circumstantial. But direct and circumstantial evidence equally helps the court to do justice. In the circumstantial cases, certain basic principles have been laid down by the Honorable Apex Court in case Shard Birdi Chandra Sharda versus State of Maharashtra, AIR 1984, Supreme Court 1622, wherein those principles are called the golden principles and are also known as Panshi to act upon the circumstantial evidence. Those circumstances, those principles are that the circumstances from which the conclusion of guilt is to be drawn must be fully established. The facts so established should be consistent only with the hypothesis of the guilt of the accused. That is to say, they should not be explainable on any other hypothesis except that accused is guilty. The circumstances should be conclusive nature and tendency. They should exclude every possible hypothesis except the one to be proved. And finally, there must be a chain of evidence so complete as not to leave any reasonable ground for conclusion consistent with the innocence of the accused and must show that in all probability the act must have been committed by the accused. These principles have also been reiterated by the Honorable Apex Court in later cases, that is Shanti Devi versus State of Rajasthan, 2012, 10 K 128, and many other Supreme Court cases. All the courts are following these principles in the circumstantial evidence to record its conclusion. Friends, there is no dispute to the basic principle of law that honors to prove is always on the prosecution. The prosecution is duty bound to prove the complete chain of incriminating circumstances. Any infirmity or lacuna in the prosecution case cannot be cured by the false plea of defense. The conditions as laid down in the cases referred above must be fully established to base conviction on the circumstantial evidence. There are various important cases which have been decided by the courts on the basis of circumstantial evidence. Some of them are Arushi Talwar murder case, Priyadarshini Bhattu murder case, VC Shukla versus State of Madhya Pradesh, State of Tamil Nadu versus Nalani and others, known as Rajiv Gandhi murder case. In all these cases, the court had based the judgments on the circumstantial evidence. The prosecution generally rely upon the incriminating circumstances like the last seen theory, abscondence of the accused after the commission of crime, a recovery of articles of crime, that is weapon of offense, blood-stained clothes, blood-stained earth from the spot, a recovery of articles of the victim from the accused, and when the which the accused fails to furnish any explanation, the matching of blood-stained group found on the clothes of the accused, a recovery of the articles belonging to the accused from the scene of crime, pointing out of the place of occurrence by the accused, the presence of the accused near or at the place of occurrence, and the false explanation of the answers to the established circumstances. These are some of the incriminating evidence circumstances which are generally put into service by the prosecution in order to prove its case. As already mentioned, circumstantial evidence includes all the relevant facts. It is nearly the direct evidence applied indirectly. It can be stated in this manner that when a fact is put before the court, that fact itself may not tell anything about the commission of the offense, but it allowed the court to make some assumption and draw some inferences that the offense has been committed by the person charged. It is generally seen that circumstances do not relate directly to the crime, but those indirectly point to the crime. In appreciating a case based on circumstantial evidence, one circumstance by itself may not unerringly point to the guilt of the accused. There has to be complete chain of incriminating circumstances to bring home the guilt of the accused. Reference can be made to case Angeles Dangdo versus State of Jharkhand, 2006, Volume 4, RCR Criminal 831. The collection of circumstantial evidence is a difficult job for the investigating agency, but in certain cases, there is no option left with the investigating agency to bank upon the circumstantial evidence. For example, in a case of blind murder, rape with a murder, theft, a roadside accident, etc. In such circumstantial evidence, the collection of fact, when considered together, can be used to infer a conclusion that sometimes or something is known. Circumstantial evidence is used to support a story of sequence of events, which is supported by significantly significant quantity of corroborative evidence. Section 106 of the Evidence Act, now 109 of the Bharatiya Sakshya Adhiniyam, is very important and it has great application to the cases based on the circumstantial evidence. This provision of law provides that when any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. Section 106 of the Evidence Act and 109 of Bharatiya Sakshya Adhiniyam are exactly analogous, having the similar wording. In the landmark judgment titled as Shambhunath Mera versus State of Ajmer, AIR 1956 404, the Honorable Apex Court has laid down that Section 106 is an exception to 101 of the Indian Evidence Act. Section 101 of the Evidence Act laid down the general rule about the burden of proof. It enacts that whoever desire any court to give judgment as to any legal liability dependent on the existence of fact which he asserts must prove those facts actually exist. This provision of law laid down the general rule that in criminal cases the burden of proof always rests on the prosecution. But Section 106, now 109, is an exception to the above general rule. It provides that any fact which is especially within the knowledge of any person, the burden of proving that fact rests upon him. This provision is not intended to relieve the prosecution of its basic duty of proving that accused has committed the offense with which he is charged. On the contrary, it is designed to meet certain exceptional cases in which it could be impossible or at any rate This disproportionately difficult for the prosecution to establish the facts which are especially within the knowledge of accused and which the accused would prove without difficulty or inconvenience. In our practical life, we have seen many cases where the facts are especially within the knowledge of the accused. From that is from where he has purchased the weapon, from where he got the poison, and how he stored it, where it is stored it. All these things can be revealed, can be have to be explained by the accused. Otherwise, the presumption under Section 106 of the Evidence Act shall be drawn against the accused. But especially stress that it means the facts which are preeminently or exceptionally within knowledge of the accused. The Privy Council in case Atya Gali versus King, AIR 1936, Privy Council 169, has refused to construe this section to mean that a burden lies on an accused person to show that he has not committed the crime for which he is tried. Section 106, Evidence Act, now 109, Bharatiya Sakshya Adhin, should be applied with great care and caution in all the criminal cases. The ordinary rule that applies to the criminal trials is that onus lies on the prosecution to prove the guilt. This burden is never shifted and is not modified even by the opposite provisions. If the prosecution fails to prove the essential ingredients of the offense, no duty is casted upon the accused to prove his innocence. But once the burden is discharged by the prosecution, it is for the accused to prove the facts, especially within his knowledge. For example, in a case of the death of a housewife by drowning in the well in the courtyard of her house or her in-laws, wherein at the time of incident only the victim and accused were present in the house, and there was and there was evidence to show that accused willfully treated the deceased with cruelty. It was the duty of the accused to prove as to what happened, which resulted into the death of his wife. The Honorable Apex Court, in a recent judgment titled as Anis versus State of Government of NCT, Criminal Appeal number 437 of 2015, decided on 3rd May 2024, had dealt with the scope of Section 106 of the Evidence Act. In that case, a lady, namely Sarah, was married to Abdul Darwish. The marriage was solemnized in the year 1982. On 29th December 1995, Sarah was found lying in a pool of blood, having suffered multiple deep stab wounds in the abdomen and other part of the body. The accused was also found present at the place of occurrence by the police. He was having few superficial injuries. Both the deceased and the accused were shifted to the hospital where the deceased was declared brought dead and accused was discharged after some preliminary treatment. During investigation, Shahina, the 5-year-old daughter of the deceased, made the statement that upon hearing the cries and shouts in the night, She woke up and witnessed that her father, that is the accused, inflicted knife injuries on the body of her mother. But during trial, Shahina, the sole eyewitness of the incident, failed to support the prosecution case and rather stated that some thieves have entered their house and they caused stab injuries to both her parents. The land trial court, on appreciation of the circumstantial evidence, held the accused guilty for the offense of murder punishable under Section 302 Indian Penal Code. The appeal preferred by the accused was also dismissed by the Honorable High Court. Thereafter, the accused preferred the further appeal to the Honorable Apex Court. In this factual background, the Honorable Apex Court had occasion to interpret the scope of Section 106 of the Evidence Act. By taking note of its various previous judgments, the Honorable Apex Court concluded that the court should apply Section 106 Evidence Act in criminal cases with care and caution. It cannot be said that it had no application in the criminal cases. The ordinary rule which applies to the criminal trials in this country that onus lies on the prosecution to prove the guilt of the accused is in no way modified by the provisions contained in Section 106 of the Evidence Act. It was further laid down that this section cannot be invoked to make up the inability of the prosecution to produce evidence or circumstances pointing to the guilt of the accused. This section cannot be used to support a conviction unless the prosecution has discharged the onus by proving all the elements necessary to establish the offense. It was finally observed that until a prima facie case is established by the evidence led by the prosecution, the onus does not shift to the accused. It was also observed by the Honorable Apex Court that Section 106 of the Evidence Act has no application to the cases where the fact in question, having regard to its nature is such as to be capable of being known not only to the accused but also to the others. If they happen to be present when the occurrence took place. It was further observed by the Honorable Apex Court that if an offense takes place inside the four walls of the house, in such circumstances, the accused had an opportunity to plan and commit the offense at a time and in the circumstance of his choice. It will be extremely difficult for the prosecution to lead evidence to establish the guilt of the accused. No member of the family, even if he is witness to the crime, would come forward to depose against another family member. The Honorable Apex Court held that it is to resolve such a situation. Section 106 of the Evidence Act exists in the statute book. The Honorable Court, taking into consideration the circumstances coming on court, upheld the conviction of accused Anis. The Section 106 and 109 plays a significant role in the cases based on circumstantial evidence. Now, let us discuss the evidentiary value of the incriminating circumstances generally relied upon the prosecution. At the cost of repetition, it is pertinent to mention that a single circumstance cannot complete the chain of incriminating evidence circumstances. It is the cumulative circumstances which forms the change and helps the prosecution to establish the charges. Last scene theory is generally projected by the prosecution in such cases to prove the guilt. In such cases, the time gap is a very important deciding factor. To establish last scene, the time between last scene alive and the death should be shortest one. Reference can be made to case Keshav versus State of Maharashtra, 2009, 101, Supreme Court cases criminal 184. The company of the accused and the deceased has to be established by quoted evidence. Further, the time gap between last seen alive and recovery of dead body should be so small that possibility of any person other than the accused being the author of the crime becomes impossible. In such circumstances, the theory of Nazi plays its role against the accused. Reference can be made to case Ram Reddy, Rajesh Khanna Reddy, and another versus State of Andhra Pradesh, 2006, Volume 3, Supreme Court Cases Criminal 512. The last scene theory can only play its role once the homicidal death is proved. In the absence of proof of homicidal death, the last scene theory has no value. It was so laid down in case Madhav Singh versus State of Rajasthan, 2002, Criminal Law Journal 1694. The possibility of deceit having left the company of the accused should not be there. The requirement of time gap being short between deceit and last seen alive in the company of accused and the death rules out the possibility of any other person than the accused being the author of the crime. If there is a long gap, the possibility of other person coming in between will exist and theory of last seen will lose the evidentiary value. Tahir versus State, 2001, RCR Criminal, page 32. At the same time, the testimonies of the witness of last seen theory should inspire confidence. There should not be inordinate delay in recording the statement of such witnesses. Reference can be made to case N. Swamy alias Putta Swamy versus State of Karnataka, 1998, Volume 2, Crimes, 271. In that case, the statements of witnesses were recorded by the police after 2 months of the arrest of the accused. The last seen theory was discarded by the court. It is also the basic principle of law that mere last seen theory is not sufficient to record the conviction. Reference can be made to case Dhanmant Singh versus Dhanmant Singh versus Juti Chandigarh, 2007, Volume 2, RCR Criminal 868, Muhammad Azam versus State of Punjab, 2005, Volume 3, RCR Criminal 464, and many other cases can be referred. In Amarinder Kumar versus State of Punjab, 2011, Volume 1, RCR Criminal 690, it was laid on that it is not safe to pass conviction only on the basis of large theory. It may, at the most, the last known theory may raise a conviction, but sole last known theory is not sufficient to base conviction. Thus, as per the ratio of law laid down in the cases referred above, the time gap between last seen alive together and recovery of death body should be short to rule out the possibility of intervention of anybody else than the accused. The last seen theory should be based on cogent and reliable evidence. Mere last seen theory is not sufficient to base conviction. At the same time, if last seen theory is available and is corroborated by other incremental circumstances, it can be safely relied upon to establish the view. Then the abscondence of the accused after the commission of the crime is also relied upon by the prosecution in number of cases. The Honorable Supreme Court in case Ravindra Kumar Pal alias Dara Singh versus Republic of India 2011 Volume 1 Supreme Court cases criminal 706 has laid down that abscondence is relevant as conduct under Section 8 of the Evidence Act and can be taken into consideration along with other evidence to prove the guilt. Similar ratio of law has been laid down in case Shaimal Ghosh versus State of West Bengal 2013 Volume 1 RCR Criminal 770. Reference can also be made to case Manish Diksha and others versus State of Rajasthan AIR 2001 Supreme Court 93. But at the same time, abscondence of the accused after commission of offense by itself not necessarily lead to a conclusion of guilty mind. Even an innocent person may feel panky and try to evade the arrest when wrongly suspected to a grave crime. Reference can be made to case state through CBI versus Mahinder Singh Daya 2011 Volume 1 RCR Criminal 706. Thus, the abscondence alone can also be no ground for conviction, but it can corroborate the other incriminated circumstances. Then the recovery of articles of the crime is another important incriminating circumstances generally put forward by the prosecution in almost every criminal case. Sometimes the weapon of offense recovered from the accused is found stained with blood. The recovery of weapon of offense from the accused is an important link in the chain of the circumstances. But in order to supply the link in the chain of circumstantial evidence, the recoveries of the crime article has to be proven by leading cogent and convincing evidence. Normally, such recoveries are made on the basis of disclosure statements made by the accused under Section 27 of the Evidence Act, now proviso to Section 23 of the Bharatiya Sakshya Adhiniam. It is mandatory that at the time of recording the disclosure statement, accused must be in police custody. Otherwise, such disclosure statements will not be admissible in evidence. The disclosure statement so recorded must lead to the discovery of the fact. And if no recovery is effected, such disclosure statement is again inadmissible in evidence. Generally, the court requires the independent corroboration to the recoveries, but in certain cases, the non-joining of the independent witnesses is no ground to discard the recoveries. If there is possibility of planting the crime articles, such recoveries carries no evidentiary value. If it is proved that place of concealment was already known to the investigative officer, or it is affected from place accessible to the general public, such recoveries are also of no legal consequences. It is also necessary that recovered articles should be seized immediately in order to rule out any tampering with. The doubtful recoveries cannot form the basis of conviction. Reference can be made to case Babu Das versus State of MP 2003, Criminal Law Journal 2536. Then the recovery of articles of victim is also an incremental circumstance. The same rule regarding appreciation of evidentiary value of recovery of such article is applicable. That is, it must be based on cogent and convincing evidence. Comma. The accused should be in exclusive possession of the articles. It should be proved that such article belongs to the victim. If the recovery of article of victim or blood-stained weapon is effected from the accused, for which no explanation is coming forward from the side of the accused, then Section 106 of the Evidence Act, now 109 of Bharatiya Sakshya Name, comes into play and the presumption arises against the accused. The articles of the deceased allegedly recovered from the accused should be identifiable and connected to the victim. The recovery of general type of articles, which are easily available in the market, will carry no accuracy value. It is seen that sometimes the recovery of some articles of the victim, which carries no value, is shown by the investigating agency just to create evidence. It is not probable that in such serious crimes, the accused will take such simple articles of less value with him, knowing fully well that such articles can be used against him. In various murder trials, it was found that the recovery of Aadhaar card, driving license of the deceased, bank passbook, or ration card of the accused or the deceased is shown. It is not expected that accused will carry such articles with him, which is of no use to him and cannot be made basis to constitute the incriminating evidence. Reference can be made to case Purvan Singh and others versus State of Madhya Pradesh, AIR 2002, Supreme Court, 1 In one case, the recovery of shirt of the victim was allegedly effected from the accused. The court held that there could be no possibility of removing the shirt of the victim and keeping the same with him when the aim of the accused was to extort money. It was held to be a case of plantation to create evidence. A reference can be made to case Ansar Pasha and another versus State of Karnataka 2000, Criminal Law Journal 5066. Similarly, in one case, the recovery of blood-stained clothes was shown from the accused after many days of the occurrence. The court held that it is not expected that accused will keep on wearing the blood-stained clothes much after the occurrence. In case of recovery of ornaments, watches, etc., the proper identification is required to be held to establish the identity. There should be some specific mark on such articles to connect it with the victim. In the absence thereof, such recovery will have no value. It is also it had also been held in a case BL Stitch versus State of Karnataka 2002 Criminal Law Journal 3508 that single circumstance of recovery of ornaments of the victim from the possession of the accused is not sufficient to attract conviction. Thus, recovery of crime articles and articles belonging to victim from the possession of the accused can be used as an important incriminating circumstance if it inspires confidence. Similarly, the recovery of articles belonging to the accused from the place of occurrence can be used against him, provided that such article should be properly connected to the accused. The pointing out of the place of occurrence is also relevant under Section 8 of the Evidence Act. Now, Section 6 of the Bharatiya Sakshya Adhin as conduct of the accused. In the same manner, the presence of the accused near or at the place of occurrence in close proximity to the time of occurrence can also be used as incriminating circumstance against the accused. In one case, the accused was found present at the spot where the ransom was to be given, and his fleeing from the spot on seeing the police was held to be admissible in incriminating circumstance. Reference can be made to case A.N. Venkatesh and another versus State of Karnataka, 2005 Supreme Court cases criminal 1938. The false explanation of the answer given by the accused to the established circumstances fills the lacuna in the chain of incriminating circumstance. It was so held in case of Aftab Ahmed Ansari versus State of Uttarakhand, AIR 2010, Supreme Court 773. In that case, one Jasmine, age 5 years, was found missing in the evening of February 5, 1998. On 8th February 1998, her dead body was found lying on the public way in front of the house of one Haji Khurshid. The postmortem examination was carried out, which revealed that the deceased was subjected to rape and thereafter strangulated. Two persons were charged, that is, Aftab Ansari and Bang Mumtaz. They made the disclosure statements on the basis of which the frock of the deceased stained with blood, one white cotton underwear stained with blood, one bed sheet with penalty of blood marks were recovered from the house of the sister of the accused. On completion of investigation, the charge sheet was filed. On appreciation of evidence, both the accused were convicted by the Land Trial Court for the commission of the offences provisioned under Section 302, 366, 376, and 201 Indian Penal Code. The death penalty was awarded to both the accused. On appeal, the Honorable High Court set aside the conviction of Mumtaz, but confirmed the conviction and sentence of Aftab Ansari. However, his death sentence was modified to regressive imprisonment for life. The Honorable FS Court, while hearing the appeal of convict Aftab and Ansari, held that chain of circumstances, when taken together, is conclusive in establish the guilt of the accused. It was held that incriminating circumstances proved on record were put to the appellant by recording his statement under Section 1313 CRPC, and the accused merely denied the same. The Supreme Court held that such denial on the part of the appellant and failure to explain the circumstances proof will have to be treated as an additional link in the chain of circumstances to bring home the charge against the appellant. Now, Honorable Apex Court in case Alamgir State of NCT AIR 2003 Supreme Court 280 has laid down that false explanation of the occurrence by the accused fits in the chain of incriminating circumstances. Same ratio of law has been laid down by the Honorable Apex Court in case Anthony D'Souza and others versus State of Karnataka AIR 2003 Supreme Court 25 8. Take, for example, when in a murder case, the accused offered the explanation that death had occurred due to poison, but the said plea was falsified by the chemical report of the viscera. Such false explanation supplies the link in the chain of incriminating circumstances. I must state that nowadays the majority of the crimes are blind, having no ocular evidence, and prosecution has to collect the circumstantial evidence to trace out the culprit and to seek punishment. During the course of my long judicial career, I had opportunity to deal with number of criminal trials. In a very less number of cases, eyewitnesses account were available, but in the majority of cases, there was circumstantial evidence. The circumstantial evidence is mainly helpful in the cases where the crime has taken place in the four walls of the house. A family member of the accused will seldom come forward to support the prosecution. Similar is the position in the cases of honor killing and rape with murder. The circumstantial evidence is no longer a weak piece of evidence, but in exceptional cases, it is stronger than the direct evidence. As there is a famous saying that man may tell lie, but circumstances can never be. But at the same time, the courts are required to take due care and caution to act upon the circumstantial evidence. The evidence produced before the court to establish incriminating circumstances should be cogent, convincing, and reliable. In order to sum up, I must mention that to act upon the circumstantial evidence, the circumstances from which the guilt is to be drawn should be fully established. The facts so established should be consistent only with the hypothesis of the guilt of the accused. That is to say, they should not be explainable on any other hypothesis except that accused is guilty. The circumstances should be of a conclusive nature and tendency, and they should exclude every possible hypothesis except the one to be proved. And there should be a complete chain of evidence so complete as not to leave any reasonable ground for conclusion consistent with the innocence of the accused and must show that in all human probability the act must have been committed by the accused. It is also chattel law that in cases based on circumstantial evidence, if two views are possible, the one favorable to the accused has to be taken. The lacuna in the prosecution case cannot be cured by the false defense. The principles laid down in Section 106 of the Evidence Act and now 109 of the Bharatiya Sakshya Act shall be applicable only when the incriminating circumstances are established, are prima facie established, then the burden shifts to the accused to prove the facts, especially within his knowledge. There should be legal evidence for conviction. No conviction can be based on the moral ground, even though detail of suspicion did point to the accused. Now, to conclude, I hope that today's interaction will be beneficial to the viewers, particularly the budding lawyers. Any anybody want to say anything is welcome. Hello, Vikas. Hello. Hello.
Yes, sir.
Just because,
I'm just checking as to whether there are any questions.
hello.
No, sir, there are no questions. Hello.
Yes, your voice is not clear.
Sir, I'm saying there are no questions asked on the chat box as well as on the YouTube.
Okay, then okay. Thank you. Thank you for patiently hearing.
Thank you.
Tengo, no. Tengo el cargas.